name's Ken Bauman. I'm a volunteer at Immigrant Solidarity DuPage, a 501c3 organization in Wheaton, Illinois. Julieta?
Hi, my name is Julieta Garcia.
No. Interpret for me, please.
Oh, okay. El señor es Ken Bauman de la organización Immigrant Solidarity DuPage.
Okay. We're receiving calls from people in the Latino immigrant community about landlords threatening eviction for non-payment of rent.
Hemos estado recibiendo llamadas de inquilinos diciéndonos que reciben amenazas, están siendo hostigados por los dueños de edificios que rentan.
As a community service, we've asked Judge McCluskey of the DuPage County Circuit Court
Como una organización de la comunidad, hemos llamado al juez del circuito de DuPage para contestar preguntas. El juez
to talk to us about renters' rights and evictions.
para que nos hable de los derechos de los inquilinos.
We'll do this mostly scripted interview in English, as that's my and Judge McCluskey's primary language.
¿Será esto en inglés mediante el juez McCluskey y Kenneth Bauman?
We're doing this interview on September 10th, 2020.
Hoy es el jueves 10 de septiembre 2020.
We'll provide links to further information and aid agencies wherever the video is posted.
Vamos a compartir enlaces e información con este video para su información.
Julieta is our interpreter. Julieta, please introduce yourself.
Buenas tardes, soy Julieta Alcántara García. Yo vivo aquí en el área de DuPage y soy miembro de Immigrant Solidarity DuPage. I am from Immigrant Solidarity DuPage.
Judge McCluskey, please introduce yourself and give us a short bio.
Okay. My name is Judge James McCluskey.
Él es el juez James McCluskey.
I have been a licensed attorney for 41 years.
Ha sido un abogado licenciado por 41 años.
Within that time, I have been a judge for 2.5 years.
Dentro de ese tiempo ha sido un juez por 2 años y medio.
Currently, I am the judge who handles all evictions in DuPage County.
Actualmente soy el juez que preside los casos de evicción en DuPage.
I'm most grateful to be here to present my discussion on evictions in DuPage County.
Estoy agradecido por la oportunidad que se me da para hablar sobre mi opinión sobre este caso.
Thank you.
Gracias.
Okay. So to start off with, Judge McCluskey, if you could please give us a brief description of Chancery Court where these eviction matters are heard.
Thank you, Ken.
Juez McCluskey, que si nos pudiera dar una explicación de estos casos que ha recibido usted.
Okay. Chancery Court evolved from the Middle Ages through the Renaissance, and it was based on church doctrine, the Catholic Church doctrine.
Este tipo de corte que él ha asistido de los casos han sido en el pasado doctrinas de iglesias.
It is basically a court of fairness and equity. That is the principle behind Chancery Court.
El propósito de Chancery Court Eso es para que haya equidad, para que sea parejo todo lo que concierne a rentar a personas, rentar apartamentos, viviendas.
In Chancery Court in DuPage County, we have foreclosures, evictions, probate, and guardianship cases.
Chancery Court, ese tipo de corte ayuda en casos de guardias, de evicciones y de muchos títulos.
Primarily, eviction cases are decided by a judge as opposed to a jury.
En este tipo de casos, lo primordial son las evicciones que se determinan por un juez, no un jurado.
Thank you.
Gracias.
All right. Immigrant Salary DuPage is receiving numerous calls from tenants who are being threatened with eviction by landlords.
Solidaridad Inmigrante DuPage hemos recibido muchas llamadas donde los dueños de viviendas los amenazan con evicciones.
Can a landlord evict someone without the involvement of the legal system?
¿Puede un dueño de vivienda hacer una evicción sin procedimiento legal?
The simple answer is no, and I will explain.
La respuesta simple es no y voy a explicar.
The whole idea of the American judicial system is that disputes involving a landlord-tenant have to be decided in the courts.
Todo el plan del sistema judicial es para que se determine un caso entre un dueño y un inquilino en la corte.
The law in Illinois does not allow self-help repossession by the landlord. The landlord must go to court to evict.
La ley estatal en Illinois prohíbe que el dueño de viviendas haga una evicción por sí solo. Tiene que recurrir a un procedimiento legal.
The tenant has the superior right to possession of the premises, and the landlord must prove that the tenant breached the lease and has a right to take over the premises.
El inquilino tiene derecho sobre el área y las cosas dentro de donde está ocupando él o ella. El dueño de la vivienda tiene que comprobar mediante la corte que no cumplió el inquilino con su contrato.
Thus, only a judge in the state of Illinois, and certainly in DuPage County, can decide the rights of a landlord and tenant.
Entonces, solamente un juez en Illinois y en el Condado de DuPage puede determinar los derechos de los inquilinos y del dueño de vivienda.
Okay. If someone has been sort of forced out or effectively evicted without a court order, what, if any, recourse do they have now?
Si algún inquilino ha sido corrido sin este procedimiento legal de su apartamento o vivienda, ¿qué puede hacer el inquilino?
They would have a right to go into court and re-seek possession of their tenant property, which is called the tenancy.
El inquilino tiene derecho de ir a la corte con este caso para recibir el derecho de entrar en su vivienda.
A sheriff who performs the actual physical eviction process will not remove the tenant without a judge's court order.
El alguacil no va a remover a ningún inquilino sin la orden de un juez.
In other words, if a landlord took possession without a court order, they would be in violation of the law and would be a trespasser on the tenant's property.
Entonces, el dueño de vivienda, si corre a su inquilino sin un procedimiento legal, entonces está violando las leyes del estado de Illinois.
The landlord, if they attempted to remove the tenant from the property without a court order, will be subject to contempt of court.
Un dueño de vivienda, cuando corre a uno de sus inquilinos sin procedimiento legal y sin autorización, tendrá que comparecer en la corte por la violación.
Those contempt orders consist of fines, penalties, or to an extreme situation, jail.
Y las consecuencias de esas acciones en la corte serán multas, suspensiones y también cárcel.
The only process available in a landlord-tenant relationship for eviction is for the landlord to file an eviction case, serve the tenant, and be properly before a court, which would be my court in DuPage County, and then I would then hear the case and decide the rights of the parties.
El único que puede decidir cualquier cosa en estos casos es un juez como yo, que hago estas decisiones aquí en el Condado de DuPage.
Thank you.
Gracias.
Can you give us a summary description of Governor Pritzker's stay of evictions?
¿Nos puede dar una descripción de la ayuda del Governor Pritzker de las evicciones?
The governor has executive powers for emergency situations that last 30-day periods.
El gobernador tiene el poder ejecutivo de 30 días. De 30 días cada orden. Él tiene el poder de ayudar a aliviar las evicciones.
The governor has continued the 30 days since his first order of April 23rd, 2020. So his 30-day orders have been extended 5 times.
El gobernador ha extendido 5 veces su orden ejecutiva de ayudar y proteger a los inquilinos en contra de las evicciones.
Currently, the governor has stayed the eviction or has entered a moratorium on evictions until September 22nd for residential properties only.
Ahorita el gobernador ha extendido el moratorio de las evicciones hasta el 22 de septiembre.
As of August 22nd, there is no longer a moratorium on commercial property and evictions on commercial property.
Desde el 22 de agosto, los comercios son los que ya no tienen extensión del moratorio en contra de las evicciones.
Thank you.
Okay.
Gracias.
Does the governor's order apply to the undocumented?
Yes, it applies to all tenants, undocumented or documented.
La orden ejecutiva del gobernador aplica a la gente indocumentada y el juez McCluskey respondió sí.
Does it apply to evictions for any reason or just inability to pay due to loss of income related to COVID-19?
The moratorium on evictions is not.
Well, Julieta needs to.
Yeah.
Oh, I'm sorry. I apologize.
That's okay, that's okay.
Sorry.
La pregunta fue, could you repeat your question, Ken? One more time, please.
Sorry.
No, that's okay. That's okay. I should be writing this down.
Does the governor's order apply to evictions for any reason or just an inability to pay due to loss of income related to COVID-19?
La pregunta que hace Ken es si la orden ejecutiva del gobernador Pritzker aplica a todas las evicciones o nada más a las que han sido afectadas por el COVID-19.
The governor's moratorium on evictions is due to the pandemic based on two reasons, one on economic and one on health reasons. Therefore, the inability to pay due to COVID is a subset of the moratorium. There is a ban on evictions on any reason for the inability to pay.
Okay. En este momento, todas las evicciones son prohibidas, porque en estos momentos la primordial causa de la inhabilidad de pagar es COVID-19. Entonces, todas las evicciones son incluidas.
Okay. This does not relieve the tenant from the responsibility by contract, which is the lease, to pay according to the terms of the lease. It just bans the ability of the landlord to evict through the sheriff's deputies process.
Esto no perdona la deuda acumulada de las rentas que se debe, sino prohíbe la evicción en estos momentos. Okay.
All right. President Trump recently signed an executive order that claims to prevent evictions. Now, could you please provide your understanding of that executive order and its effects?
El presidente Trump supuestamente acaba de firmar una orden ejecutiva que prohíbe las evicciones. ¿Nos puede explicar?
President Trump directed the Center for Disease Control to look at the health issue of allowing evictions to proceed during the pandemic. He also directed the Center for Disease Control to confer with the Secretary of Health and Human Services. And the Secretary of Health and Human Services issued a finding that evictions moratorium should be extended to December 31st, 2020.
El presidente Trump pidió consejo al CDC, el Centro de Enfermedades en el país. Y la secretaria de ese lugar confirmó que sí se debería de evitar las evicciones durante este momento de COVID-19, a no desalojar a las personas afectadas. Y el presidente Trump ordenó que no se corriera nadie, no hubiera evicciones hasta 30 de diciembre del 2020.
The administrative office of the Illinois courts, which is a arm of the Illinois Supreme Court, sent a directive to all of the judges in eviction court explaining the effect of the presidential guidance or executive order that was sent to the CDC and the Secretary of the Health and Human Services.
Aquí en el estado de Illinois se le ha instruido a todos los jueces a revisar esta orden bien y a acatar los requerimientos de esta nueva orden.
No additional guidance was given by the Administrative Office of the Illinois Courts as to the effect of President Trump's executive order to the Center for Disease Control and the Secretary of Health and Human Services.
El estado de Illinois no ha respondido nada acerca de cualquier efecto que pueda tener esta nueva orden ejecutiva con el CDC.
I interpret this as a intention by the federal system, that being President Trump, indicating to the states that the states should extend the moratorium to December 31st. It is questionable whether President Trump or the Secretary of Health and Human Services has a control over the state courts.
Eso al juez le da un aviso a él. Él piensa que no se está midiendo bien el impacto que va a tener con el estado. Se piensa que todos los estados tienen que acatar hasta el último de diciembre. Y ojalá.
If past history has shown that Governor Pritzker has followed the federal rationale, it is expected that the moratorium will be extended beyond September 22nd.
Sí, revisa bien el gobernador Pritzker la orden del presidente Trump. Él entonces, lo más probable es que sí extienda el moratorio hasta el último de diciembre 2020.
Governor Pritzker currently is offering approximately 33,000 landlords a $5,000 grant in exchange for not to evict until December 31st, 2020. And that's money that was received through the federal government for COVID.
El gobernador Pritzker está dando a 33,000 dueños de viviendas $5,000 para evitar las evicciones a sus inquilinos. Y hasta el último de este año 2020. Y eso es fondos federal.
Since this is a state court question, we will have to see what Governor Pritzker does immediately prior to September 22nd. My speculation is that he will extend his order.
Vamos a ver qué decide el gobernador Pritzker, y su especulación del juez es que sí va a aceptar el moratorio, extenderlo hasta el último de diciembre 2020.
Thank you.
Gracias.
Okay. What should a tenant do while the stay is in effect, what should a tenant do when threatened with eviction by the landlord when they're unable to pay due to the COVID-19 pandemic?
¿Qué puede hacer un inquilino cuando el dueño de su vivienda lo está amenazando con evicción por no poder pagar por el COVID-19?
There have been landlords, specifically what I would call landlords who hold smaller units of property, that will file an eviction case during this moratorium. The clerk of the circuit court will accept it. However, they will not be evicted due to the governor's moratorium order.
El inquilino puede ir a la corte del circuito a entablar un caso, pero el dueño de vivienda no los puede correr.
The clerk of the circuit court has to accept the filings, but it's up to the judge to apply the law. And the law is there is a stay on evictions. The sole judge in DuPage County is me, and I will not evict and violate the governor's order.
El clero del Circuit Court tiene que aceptar los casos cuando ya están archivados, pero el juez no va a ir en contra del moratorio del gobernador Pritzker.
Okay, thank you.
Gracias.
In other words, the landlord can threaten all they want, but if there's a moratorium, they cannot evict. There won't be an eviction process.
En otras palabras, son amenazas. Pueden amenazar el dueño lo que quieran, pero no los pueden correr y el moratorio es para evitar las evicciones.
If there is other reasons other than non-payment of rent, I will hear those reasons, and there can be an eviction if there's health, safety considerations that create imminent threat to other tenants on the property and other property owners.
El juez, él escucha todos los casos y la única forma es que si alguien está amenazando la salud de los demás, pero si no es ese caso, las evicciones no se permiten.
For example, if there is a tenant that is conducting an illegal operation on the premises that could be harmful to the residents in the surrounding premises, such as a drug wholesaler, illegal drug wholesaling operation, that would be a reason to evict for health and safety and welfare of the community.
Un ejemplo que da el juez es que si alguien está teniendo una conducta inadecuada, como vender drogas o algún acto que vaya a afectar la seguridad y la salud de los demás viviendo en esa vivienda, entonces sí se da razón de una evicción de esa persona.
But if it's just non-payment of rent, inability to pay, there's a moratorium. Eviction will not occur.
Pero si la razón es porque no ha podido pagar en estos tiempos de COVID, por el moratorio, nadie sufrirá una evicción.
Right. Is there any limit to the number of times a landlord can contact or harass a tenant to collect rent?
I'm sorry.
Las amenazas de los dueños, existen límites para los dueños de viviendas.
The rental payments are usually due on a monthly basis. Demand can be made on a monthly basis. A constant demand, everyday demand on that can subject to the landlord to improper collection procedures. And the tenant can seek relief from the court, certainly if the case is before the court and there is a stay of moratorium on evictions going on, which there is. So at that point, communication to the landlord is most important, to let the landlord know that there is a moratorium and stop constantly requesting payment.
Cada mes se debe la renta. Entonces tiene el derecho de tratar de conseguir la renta de cada mes. Lo que hay límites es constantemente, es cada semana, diario, estarlos hostigando por el pago de la renta. Entonces eso es hostigamiento y eso no está permitido y el inquilino puede acudir a la corte.
Certainly, if other arrangements can be made, I always encourage the tenant to make some payment to show a good faith effort that they really want to pay the landlord. They're just an inability to meet the requirements of the lease. The tenant should always make every attempt to make some payments to the landlord to meet those obligations, which shows a good faith effort to pay.
Todo el inquilino, dentro de sus capacidades, puede negociar con el dueño de las viviendas y también dar lo poco que pueda dar, negociar ese término para que el dueño vea que hay voluntad para pagar su renta. Pero puede negociar, puede intentar dialogar con el dueño de la vivienda.
Okay. Can a tenant sort of ignore the landlord's, constant collection attempts? And if so, are there any measures the tenant should take first? Besides, as you mentioned, making a rent payment.
¿Pueden los inquilinos ignorar al dueño de la vivienda todas las veces que los hostigue?
My suggestion before you are in a court process is that the tenant should always document their response to the landlord. The landlord asks for payment and the tenant cannot pay at that time. The tenant should communicate that in writing and give the reasons why, so that the landlord knows exactly where the tenant stands.
Es mejor que los inquilinos se comuniquen y graben, documenten la conversación con el dueño de la vivienda. Así se sabe cuántas veces va el dueño de la vivienda a acordarles, a hablarles, y lo que dijo los inquilinos al dueño.
I'll give you an example.
Les doy un ejemplo.
I've had cases before me in which the tenant could not pay on the first of the month, but received their pay check on the 15th of the month. And therefore, I adjusted the lease so that the payments would be made on the 15th of the month, because it was impossible for the tenant to pay on the first of the month.
Por ejemplo, un inquilino que el juez ayudó, tenía el primero del mes que pagar su renta y eso era imposible porque en su empleo lo pagaban cada 15 del mes. Entonces el juez pudo ajustar esa fecha para el 15 de mes en donde el inquilino podría pagar algún dinero.
Remember, I'm an equity judge. I'm trying to be fair to both sides. The landlord should be paid, but if circumstances change with the tenant, we have to adjust and make sure that the tenant has all the opportunity to stay in the premises, but that the landlord gets paid. If we have to adjust the timing of the payments, that's what a court of equity, an eviction judge can do.
En una corte de equidad donde está el juez, él hace lo posible por tener equidad por las dos partes, que se le pague a el dueño de la vivienda, pero también si hay una inhabilidad del inquilino para pagar, también ayudarle a que sea posible algún trato, algún acuerdo o pago.
Of course, the lease is what the contract says and when payments are made. But I find most landlords, especially when they're represented by attorneys, to be reasonable and will allow the court to adjust through the mediation skills of the judge with the landlord and tenant so that the tenant can pay and the landlord can get paid, but the tenant doesn't suffer a late fee and interest payments and finds it almost impossible to stay in the premises. The key here is to make sure that the tenant stays in the premises.
El dueño de viviendas, muchas veces, muchos de ellos sí han aceptado nuevos acuerdos decididos por los jueces en este tipo de corte. La idea es evitar las evicciones y tratar de llegar a un acuerdo donde sí él pueda inquilino pagar al dueño y el dueño no esté bien con ese acuerdo de la corte.
Thank you.
Okay. Assume for the minute that we have a case where a tenant is unable to pay due to COVID-19. What should a tenant do if they believe that they're sort of fraudulently being targeted for eviction for a reason other than their genuine inability to pay rent?
¿Qué puede hacer un inquilino si por alguna razón fraudulenta está siendo amenazado con evicción?
Well, that is the exception to the governor's executive order. And some landlords have attempted to make another claim and say it's really due to a safety issue, a severe imminent health hazard, or that the tenant is not maintaining the premises, which could cause serious harm to the building itself, such as if it's a collapse of a porch and that it'll cause great harm to the tenants below, things of that nature. What happens is they usually file the case and the court hears the evidence. And the evidence is ferreted out, and usually what occurs that I hear the case, and more often than not, I decide that it is due to the inability to pay, which is governed by the moratorium order, which would not allow an eviction.
Muchos dueños de vivienda sí intentan una evicción por decir otras razones, decir que el inquilino es un peligro a la vivienda, a los demás, algo que haya pasado en su lugar donde vive el inquilino, pero en la corte con el juez McCluskey, él toda la evidencia que existe. Y muchos de los casos ahora finalizan entre sí. La única razón por la que quiere la evicción es porque el inquilino tiene inhabilidad de pagar.
I would have to hear very compelling evidence that I would have to be persuaded that the reason for the eviction is not related to non-payment, but related to some serious infractions for health, safety, and welfare. And that is a big hill to climb.
Yo tendría que ver toda la evidencia que sea muy concreta y demasiado seria para que me comprueben que este inquilino es una amenaza o algo que amenaza la seguridad de los demás en esa vivienda.
I've had cases where police were called because the stereo was too loud, and they were called on 3 occasions, and they filed an eviction based on that. That is not to a level of a compelling reason to evict, but it's every case is by a case-by-case basis. But the ultimate rationale behind the governor's order is not to evict, number one, because of the health considerations if you made someone homeless during a pandemic, and number two, their actual inability to pay because of the pandemic, and that is the reason for the executive order, and that's the reason that I'm following the moratorium.
Ha existido ejemplos donde el dueño quiere proceder con una evicción por el sonido muy alto, el sonido muy alto de música, y se llama a la policía más de 3 veces, y eso es algo que el dueño lleva a la corte. Pero aquí esto no es una causa para una evicción, sino las 2 razones por las que estas evicciones están siendo prohibidas es una, la orden del gobernador Fresco, una es para evitar que quede gente sin hogar en estos tiempos de COVID-19. Y otra es para proteger a los afectados que han sido afectados del COVID-19.
Again, an eviction cannot proceed without a judge signing a court order.
Una evicción no puede proceder sin que un juez firme esa orden de la corte.
Okay. I think, well, we'll assume that evictions are going to happen once the pandemic subsides. So, Judge McCluskey, please take us through the basic sequence of events in your courtroom when a landlord pursues an eviction.
Thank you.
Vamos a ver evicciones. Por favor, juez, llévenos sobre el proceso en la corte acerca de estas evicciones.
Let me give you a little history. I've done a little research. Last year in 2019,
Les voy a dar una historia. He hecho unas investigaciones el año pasado, 2019.
there were approximately 3,600 eviction cases in DuPage County.
Hubo aproximadamente 3,600 evicciones en el área de DuPage.
Up to April 23rd, 2020, there's approximately 1,000 cases that have been filed and evictions proceeded in DuPage County.
Desde el 23 de abril han existido 1,000 procedimientos de evicciones en nuestro condado de DuPage.
In other words, less than a third have occurred this year and I suspect that there will be no evictions until the end of the year.
Yo sospecho que no habrá evicciones, quiere decir que solo ha sido una tercia en todo este tiempo del año pasado, y yo sospecho que hasta el fin del año no habrán evicciones.
Let's turn the clock to January 2021.
Llevemos este reloj a enero 2021.
At the present time, you cannot even commence an action for eviction. Therefore, the commencement would occur in January 2021.
En estos momentos no podemos ni comenzar el procedimiento de una evicción. Hasta enero 2021.
After filing a notice of what's called a 5-day notice to pay the rent, and if that does not occur, the rent isn't paid, the eviction process is started in court.
Después de 5 días de no haber pago de la renta, después de esos 5 días empieza el procedimiento en la corte para las evicciones.
The tenant needs to be served with papers, personally served or someone in the premises. That would take approximately 21 to 30 days for the tenant to appear in court.
El inquilino debe recibir los documentos, y cuando reciba los documentos tiene que aparecer en corte dentro de 21 a 30 días.
Once they appear in court, there is an attempt to either work out a payment plan or some type of settlement agreement where the landlord would seek possession, or the tenant has a right to hear the case before the judge.
Cuando tienen que comparecer en la corte, se les dará a los inquilinos opciones para poder cumplir con sus pagos de renta.
That could take another 2 weeks past the date they arrive in court, and then the judge would hear the case and decide the case.
Tendrán 2 semanas para cumplir con los pagos, y después de ese tiempo el juez decidirá el caso.
If the judge decides that the tenant must vacate the premises, an order is entered, but along with a stay, not to execute on the eviction, and that's within the judge's discretion for a reasonable time for the tenant to vacate the property.
Esa orden, si da el juez la orden de que sí, tiene que desalojar el inquilino, se le dará un tiempo adecuado para poder desalojar la vivienda adecuadamente.
Or if the tenant agrees to a payment plan when they appear in court, that could end the process if they comply with the payment plan. In other words, they pay for the past due and they receive some time for the past due payments and continue on with their payments for the rent. That could then end the process.
Si sucede que hay un acuerdo de pago del inquilino para el dueño de la vivienda, en ese momento puede terminar el juicio, el procedimiento para una evicción.
If the tenant doesn't pay and the court orders, and then there's an eviction, the sheriff goes out and puts a orange sticker on the door saying that eviction process will occur within the next 14 to 21 days. But the sheriff doesn't do that until approximately 3 to 4 weeks after the court order, because the sheriff has what's called a backlog of eviction cases. And I suspect it's going to be a lot more backed up due to COVID-19.
Las evicciones las tiene que hacer un alguacil. Se dará la orden y tiene de 14 a 21 días. Se le dará, el sheriff va a ir y se le pondrá una calcomanía anaranjada hablando de esta evicción, pero algo así no va a efectuar el desalojamiento hasta 3 semanas después de esa acción, de esa orden.
If the tenant files any motion after the trial, that motion needs to be heard, whatever the reason, before the actual sheriff can evict the tenant.
Si el inquilino archiva una defensa, algo a su favor, que pueda evitar esa evicción, hacerla antes también, eso puede ayudar a decidir, darle un moratorium a el inquilino.
Okay, and the whole process usually lasts about 60 days. However, due to this unusual circumstance of COVID-19 and this year, that process could be extended for 120 days because of the backlog of the cases. That's why I spoke about what happened in 2019 versus 2020.
Puede pasar, estamos hablando de 2021, puede pasar, normalmente estos procedimientos duran 60 días. Por todo lo que está pasando ahora, por el COVID-19, todos estos procedimientos pueden durar 120 días.
Okay. Does a tenant need to have an attorney? Can they come in themselves?
¿Necesita un inquilino un abogado?
The answer is no. The tenant does not need an attorney. We have a full-time legal aid attorney from Prairie State Legal Services. We also are having a collaboration with DuPage County Bar Association that I've worked well with, and they are volunteering 2 other attorneys to be in court besides the Prairie State legal attorney to represent the tenants. For one attorney, most difficult, but now that I have the cooperation of the volunteers from the DuPage County Bar Association, 3 attorneys in total is going to be most helpful to represent the tenants.
No necesitan los inquilinos traer abogados. Presentan sus archivos, sus casos a la corte, y en la corte existen abogados quienes ayudan a la comunidad, abogados públicos por la corte y por la asociación DuPage Bar Association.
Are interpreters available?
Yes, the DuPage County court system has 3 full-time interpreters that are fluent in Spanish, and any other interpreters that are needed, the court will then order at no cost to the tenant an interpreter to come in and speak the primary language of the tenant.
¿Existen intérpretes? Pregunta Ken, en español en las cortes. Y dice el juez McCluskey que sí. Tenemos 3 que trabajan por nosotros en las cortes de DuPage full time, y también si necesitamos más, podemos llamar a que vengan más intérpretes. Y no cuesta nada a los inquilinos.
And what sort of evidence would a tenant bring in, or should they try and bring in? And just generally speaking, what sort of evidence is reviewed?
¿Qué tipo de evidencia necesita traer el inquilino?
The first piece of evidence a judge who handles eviction court would like to see is whether there's been proper service of a 5-day notice that's pre-suit. Was the tenant actually served with what's called a 5-day notice for non-payment of rent? And did they serve them personally? If they just stuck it to the door, the landlord would have to show that that would be available by contract. Sometimes it isn't. If it is not the proper service, the notice is defective and the case is not properly before the court.
La primera evidencia que debe de traer un inquilino es que si le sirvió los 5 días, hizo un servicio los 5 días después de que no hubiera pago de su renta. Si no fue personalmente el dueño y eso no está indicado en el contrato, entonces no fue un servicio adecuado de 5 días al inquilino después de la inhabilidad de pagar.
Second proof or evidence the tenant should show is if they want to contest that they were properly served with a summons. If they want to object to that, they would have to show some evidence through either testimony or documentary evidence showing that the summons was not properly served on the tenant or someone in the premises the age of 13 and above.
La segunda evidencia es que haya prueba o un testigo de que al inquilino no se le hizo el servicio adecuado de los 5 días. Si hay un testigo o alguien que pueda documentar, que haya documentado que esto no se hizo.
Of course, the other primary evidence that they can bring in, if they contest the charges that are being brought against them by the landlord, the amounts of the charges, and whether they've actually paid the rent, and they contest that they do owe the rent. If they brought in proof of payment through checks, through statements, through credit card payments, that would then be proof to show that they have complied with the payments and therefore they're not in breach of their agreement with the landlord. That would be very good evidence to show to a judge.
La tercera evidencia que pueden mostrarles son cheques que se le pagó al dueño, su estado de cuentas, algo que compruebe que sí se le pagó la renta, se le estaba pagando la renta, pero si le están cobrando otras cosas el dueño, si le están cobrando otros cargos a pesar de la renta. Si el juez puede ver que ha estado cumpliendo con la renta, eso lo va a ayudar muchísimo.
Okay.
Thank you.
And then Judge McCluskey, I think you probably answered this already more or less, but I just want to ask again, how much discretion do you have, or can you describe the discretion you have in order to help people sort of stay in their apartments or their homes?
A lo mejor usted ya respondió esto, la pregunta de quién, pero ¿qué discreción tiene usted para poder ayudar a que se queden los inquilinos en su vivienda?
In an eviction case, usually the landlord has to prove they have a right to the premises because they own the premises, the legal title. And number two, there's non-payment of rent and they're owed rent. the judge has to make a decision based on those two premises. And if the landlord proves that and the tenant has no explanation for non-payment or reasonable explanation, and there's not a mediation to settle the case, an eviction will be ordered. However, the judge has discretion with respect to the stay of eviction.
Él tiene que ver todo acerca del juicio, del procedimiento. El dueño presenta las pruebas de que no se le ha estado pagando la renta, entonces